This is a simple introduction to precedent. It uses three hypothetical cases to illustrate the operation of precedent in our court system. The Apple case. The Apple case is set in a typical suburban neighbourhood. A dispute arises over ownership of the fallen apple, with Party A, the owner of the apple tree, arguing that it's their apple because it's their tree. On the other hand, Party B, the neighbour, is arguing that the apple fell onto their property, so it belongs to them. Now, unfortunately, this dispute's unable to be satisfactorily resolved, and it ends up in the court system. Now, the judge in the case considers the facts and makes his decision. And he decides, if an apple falls into your yard from your neighbour's tree, you may keep it. So this is the decision of the court in the Apple case. Now, the ratio decidendi, or the rule in the Apple case, is a very narrow rule. It only applies to apples that fall from your neighbour's tree. The Pear case. It's quite similar facts in the Pear case. The setting's similar, it's just a few years later. Still in suburbia, and a dispute arises over who owns the fallen pear. Now, Party A, the owner of the pear tree, makes the point that it's their pear because it's their tree. It simply fell over the fence. It doesn't make it your pear. Where Party B, the neighbour, argues that, no, I'm sorry, it's my pear. It fell onto my property. It belongs to me. Now, this dispute's unable to be resolved, and it ends up in court. And so the court considers the facts of the case, and it also considers the state of law, and that is the Apple case, the case that came before, because the cases have similar facts. And so the judge considers the law and the facts and makes his decision that if fruit falls into your yard from your neighbour's tree, you may keep it. This decision is consistent with the decision in the Apple case as well. But what has happened here is the rule or the ratio in the Pear case has a greater degree of generality than the ratio in the Apple case. In the Apple case, the rule only applied to apples. The rule now applies to all fallen fruit. So was this the only action or course of action available to the court? Were there any other options that the court could have taken in deciding the Pear case? Well, perhaps the court could have distinguished the Apple and Pear cases. To do so, the court would need to argue that pears and apples are different. That is, the facts differ. And if the facts are different enough, the precedent doesn't need to be followed. So that was another possible outcome in the Pear case. However, that wasn't the outcome, and the Pear case decided that if any fruit falls into your yard from your neighbour's tree, you can keep it. The final case is the piano case. The facts are again remarkably similar. Adjoining houses in the neighbourhood where the people with the green house decide to buy a piano and have the piano delivered and installed in an upstairs studio. Now, unfortunately, this is a very, very tricky task. There's a problem because of some ground subsidence in one part of the property. And so to overcome the problems with the site, They engage the services of quite a large and complex crane truck device to deliver the piano to deliver their piano and install it to the upstairs studio. Part of the process of delivering the piano involves swinging the piano over the neighbour's property. Only momentarily, but nonetheless over the neighbour's property. Now, unfortunately, during that process, the piano crashed to the ground. Quite remarkably, there was no damage at all to the piano, despite it crashing to the ground. Now, the problem arose because there was a dispute then over the ownership of the piano, where Party A said it was their piano, they were having it delivered, it just fell into your yard, we want our piano back. Now, Party B argued that, I'm sorry, but this piano belongs to us now because it fell into our yard. This dispute was not resolved between the parties and ultimately ended up in court, where the court considered the facts of the case, which were remarkably similar to the facts in the prior cases as well, the Apple and Pear case. And, of course, the judge considered the precedent created in the Pear and Apple cases. And he decided, if anything falls into your yard, you may keep it. This decision is consistent with the decisions in the earlier cases. What has happened here is the ratio, or the rule, in the piano case has a greater degree of generality again than that in the Pear case. The rule now applies to anything that falls into your yard. Now, serious questions arise about such decisions, and we would ask whether that decision has gone beyond a level that the community and courts would find acceptable. And the answer to that question is that courts are unlikely to make such broad decisions because indeed it would be unacceptable to the courts and to the community. Why? Because decisions that are too broad make a nonsense of precedent and of the law. I want you to think of some examples about the piano that lead on from the piano case that would be absurd, and we'll talk about that in class next week. Finally, it's important to bear in mind that precedent develops very slowly. It's a case by case by case process because the courts have to explain the reasons for their decisions, and the decisions of the courts are subject to public scrutiny and scrutiny by other courts.